Is the audio coming through now?
Yes, I'm picking up audio now.
Excellent. Thank you.
So there's 3 people back online out of, but there were 5. 4. Okay. Looks like we have reestablished communications, so you may proceed.
When we're calculating fixed avoided costs, we're looking out into the future and we're taking into account price of gas, price of energy, additional uncertainty. So when we look farther out into the future, further uncertainty is identified. We know that they're based on projections. They're our best projections at the time, but the farther you look out, the more uncertainty there is in calculating those fixed avoided costs for energy. Since the commission adopted the LMP pricing, it relies less on those future prices in calculating the avoided costs of energy. So when a new QF comes and asks for avoided cost pricing with the COD, say of 2024, we recognize that there was inherently in the resource stack that we have here, Trident and Broadreach and so forth, there was inherently some uncertainty in calculating fixed avoided costs that far out into the future. And it's unfortunate, but in the case of kelp, as we've seen now with the change in LMP pricing or real-time pricing for a facility, there's been significant rule changes or the way we set those prices. That all serves to zone in on a more accurate avoided cost of pricing. So in the case of Trident and Broadreach, when we absorbed them into our resource stack, or when we started planning on them, they had established all the parts of their LEO. So at that point, Northwestern plans on them in its resource stack, but recognizes inherently that in providing a fixed avoided energy cost, the further you are out into the future, the more uncertainty there is in it.
Does Northwestern believe that avoided cost calculations should be done consistently QF to QF?
Generally, we want to treat all QFs the same.
So in 2021, at the time that Northwestern was providing avoided cost pricing to other QFs, why didn't Northwestern provide kelp the same avoided cost pricing?
Those QFs, we started planning on them in our resource stack because they had hit all the points of a LEO and had asked for that avoided cost pricing. So we necessarily had to provide it. It was unfortunate that it's so far out into the future, a lot of uncertainty is involved in setting those avoided cost prices. So to the extent that we can get more accurate avoided cost price by getting closer to the contract termination of kelp, it would leave customers with a greater degree of certainty of indifference for bringing on the kelp facility.
Do I understand that your position to be that you believe that the avoided cost pricing in 2023 is more accurate than the avoided cost pricing in 2021 for delivery in 2024?
When we're calculating a fixed energy rate, that would be the case because we have we're not projecting so far out into the future. When we're looking at LMP pricing, real-time pricing, that's not necessarily the case because what we're providing now is a capacity price, and there's less uncertainty in the capacity pricing.
Why didn't Northwestern offer kelp a variable energy rate avoided cost when multiple letters were sent asking to negotiate an avoided cost?
I believe it was in regards to the timing of the commission's incorporation of variable energy rates. Back in January of 21, I don't believe that was yet a process the commission was saying they'd like to go towards.
But in the same calendar year of 2021, you provided other QFs with avoided costs for delivery in 2024, didn't you?
Based on fixed
Jason.
energy.
Asked and answered.
Well, that's true. So I sustain the objection, but I don't know what your purpose.
Fair enough. So, and I apologize for that. Let me go forward. So the other QFs that you provided avoided cost pricing to, do I understand what you just answered, that the avoided cost pricing for them was at a fixed energy price?
That's correct.
So why didn't you offer Kelp the same fixed energy price that you offered the other QFs in 2021 for deliveries in 2024?
Objection asked and answered.
Well, that hasn't been asked and answered. We asked them why they didn't provide the same avoided cost in general, and he said because it was fixed. And so now I'm clarifying why he didn't provide the same fixed avoided cost. It's a different question.
Yeah, I see the point. I also see the subtle difference right there. So I'll overrule the objection, but thank you for bringing that up.
Because Kelp was an existing facility, it didn't require the financing. And so we were so far from the contract expiration date that's why Northwestern did not provide the fixed avoided energy costs at that point.
But the implication of that then is that those other contracts in your position got ahead of Kelp in the queue so as to delay any capacity payment right for Kelp, right?
Not necessarily based on that, because those other QFs established site control permitting, entered into a study for interconnection and established all of those things that were the reason we brought them into our supply stack.
Does an existing QF need to establish site control and permitting to obtain a LEO?
Objection asking for a legal conclusion.
The witness just testified as to that very question for the other QFs.
He testified as to the documents those QFs provided. Now you're asking him to conclude how an existing QF can establish an LEO.
Would you restate your question? I'm at a loss to see if it's exactly correct.
So when the other QFs provided that site control and permitting information, was that part of those QFs, in your opinion, establishing a LEO?
That is in part, but what I'm saying is those are the documents that we see as being necessary for a commitment from the project to incorporate into our resource stack.
You need a commitment as to site control and permitting for a project that's been in operation for 32 years?
I would think we do.
The last thing that you say here is, the next thing you say, excuse me, and I'm going back to your D. Limiting negotiations to within 6 months of renewals prevents existing QFs from attempting to cherry pick the best time to request avoided cost calculations and claim a LEO during the course of their already existing PPAs. You see that?
Yes, I do see that.
If an existing project wants to extend its PPA, that creates an obligation on the part of that existing project for additional years of providing service to Northwestern, correct?
Just because they want to establish an extension of its PPA does not create the obligation.
If you submit a PPA on a unilateral basis that extends your current contract, that means that you are committing to provide energy and capacity beyond the current contract into future years, right?
I think it means there's an intention to extend the contract. And, you know, the reason for the site control and permitting is that we don't understand if the facility, the particular facility actually has the site control and the permits in place until we see it.
That was an old question.
Okay.
Trying to move on.
All right.
All right, let's try it this way. Why is it a bad thing if an existing QF understands there to be a future resource need beyond the term of its current PPA? Why is it bad for that QF to propose an extension of its PPA to serve that future resource need?
It's not a bad thing.
But you use the word cherry pick. Cherry pick implies that it's a bad thing, doesn't it?
Not necessarily. Well, I think cherry pick implies that a QF, an existing QF, could theoretically pick the most ideal time to get its highest avoided cost rates, such that it's perhaps yet, you know, not the COD would be way too far out into the future, for example. So by cherry picking, I'm saying that the QF may want to enter into a negotiation before it's appropriate to enter into that negotiation.
Do you want existing QFs to be proactively determining if there's a resource deficit on Northwestern system and trying to offer the ability to serve that resource deficit? Is that a good thing?
As far as QFs go, our obligation is to make sure customers are indifferent to those QFs coming online. So I don't know if I answered the question.
Is it bad for QFs to proactively determine if there's a resource need and offer contracts to serve that need to Northwestern?
I would agree it's not a bad thing for them to consider extending their projects, whatever that means exactly. I'm not entirely sure.
Okay. Let's go back to your testimony. So you can put that package away for the moment. And I'll call your attention to page 25 of your testimony, and you will be delighted to know we're moving to a different topic. You there, sir?
I'm there.
All right, at page 25, and actually I apologize, it sort of starts on 24. You have a portion of your testimony that discusses the avoided cost of capacity and the appropriate proxy resource. Do you see that, sir?
Yes, I do.
Now, Northwestern in this case proposes, for purposes of calculating avoided cost, to use a proxy resource, which is a unit with costs and operating characteristics similar to those located at DGGS, correct?
Can you ask the question again? I'm not sure I understood the question.
Sure. Northwestern proposes, for purposes of calculating the avoided costs in this case, to use a proxy resource of a unit with cost and operating characteristics similar to those of the current facilities located at DGGS, right?
Similar in the sense that it's an aeroderivative at DGGS as opposed to a dual fuel. That's what we're proposing is the aeroderivative at DG. Yeah.
Okay, appreciate that clarification. So similar in some respects, but not in others, correct?
Yes.
Okay, fair enough. Your proposal, however, does not suggest that if CALP's avoided costs are calculated on that basis, that one or more of the existing units of DGGS has to be retired, right?
Yeah, I don't suggest that.
Okay. Your analysis of the proxy assumes, hypothetically, a new unit at DGGS, right?
Yes, it does.
Now, CALP, for its part, proposes to calculate avoided cost of capacity using a proxy resource of a unit with costs and operating characteristics like those located at Yellowstone, correct?
Correct.
Nowhere in Kelp's testimony does any witness state that Yellowstone should not be built, right?
I can't verify that. I think that's generally correct, though.
Okay, but you're not aware of a portion of the testimony where Kelp is suggesting that because you use Yellowstone as a proxy, that means that Yellowstone shouldn't be built, right?
I'm not aware of that.
So would you accept that just like Northwestern is using a proxy, Kelp's approach relates to an assumption of a potential additional unit like those at Yellowstone with similar operating characteristics and costs? Is that fair?
Objection. I think he's misstating his own witness's testimony. They're not saying, all their testimony says is that they're basing the proxy on Yellowstone, not on another resource that's similar to it.
I appreciate that's counsel's answer to my question. What I'd like is the witness's answer to my question, if that's okay.
Well, I'm objecting to the extent you're misstating your witness's testimony.
Can you refer to the specific testimony that you're citing?
So hold on a second. Well, let me just restate. Maybe we can try it this way. Is it your understanding of Kelp's position that by using Yellowstone as a proxy, that Kelp is saying explicitly or implicitly that the commission decision approving that means that Yellowstone should not be built?
I agree that I do not recall any testimony from Kelp that suggested that Yellowstone should not be built.
Okay. Would you agree with me that capacity is most valuable during times of system peaks?
Yes, to the extent that we plan for capacity at system peak.
Well, and maybe try it this way. Would you agree with me that any one generating unit's capacity is most valuable at the time of system peak?
It seems like an easy answer, but I think it's actually a little bit more difficult because capacity is also valuable at other times as well. Not just at system peak, but we are planning to system peak.
In electric markets, is capacity typically priced higher during times of system peak than it is during off-peak times?
I would say generally peak demand increases pricing, but that's not always the case.
Fair enough. Would you agree with me that system peaks can often occur during conditions of extreme weather events, for example, like those experienced during Winter Storm Uri?
Yes.
Do you agree with me that during extreme winter events, both electric and natural gas supply systems can be strained?
Seems like a broad generalization, but to an extent, yes. They're not always strained, but they could be.
Can you please refer to Mr. Gorman's, again, his exhibit 12. So at the back of Kelp 3. Let me know when you're there.
I'm there.
Can I ask you to turn to page 15 of 19 of that exhibit?
I'm there.
Thank you. All right. This is a question that relates to the delivery of gas to the existing Dave Gates facilities. Do you see that?
I do.
And the answer states Northwestern contracts with TC Energy for firm capacity with delivery to its system. The capacity that DGGS has on Northwestern's gas transmission system is interruptible. Interruptible curtailment may be curtailed during a critical day. Is that correct?
Interruptible capacity may be curtailed
Oh.
during a critical day.
Thank you. That was not correct. I appreciate that correction. Okay. What does it mean? What do you know what the term critical day means?
This is actually the witness here is Luke Hansen for Northwestern, at least the answer. But a critical day is generally when there's a large strain on the system. I don't know what the actual definition of what the requirements of a critical day would be.
Fair enough. A generic understanding is sufficient for our purposes, and I appreciate your answer there. Would you agree with me that to hedge against that risk, Northwestern installed dual fuel capability at the existing units at DGGS, right?
I don't know all the reasons Northwestern installed dual fuel capability, but there is a benefit to a dual fuel capable resource at DGGS.
What is that benefit in your mind?
It's a backup source of generation or fuel for the generating facility.
And the backup source would be needed if the fuel source that otherwise serves the units was interrupted, for example, right?
Potentially.
What other reason would you need the backup other than the fuel source is interrupted?
I don't know.
Okay.
It's generally for if the fuel source is interrupted, you have a backup fuel source.
So based on that risk, Northwestern elected to install the dual fuel capability, right?
Generally, yes. There could have been other reasons, but I don't know. But
Okay.
I follow your premise here.
Fair enough. Was Northwestern's decision to install dual fuel capability at DGGS prudent in your mind?
Objection. This commission already found DGGS prudent. He's calling for a legal conclusion.
I don't think he was asking about the prudency of DGGS, but he was asking about the prudency of installing a dual fuel. Is that correct? That was my understanding of the question.
And that was all previously approved by this commission and has already established prudency. So I think he's calling for a legal conclusion from this witness that this commission has already rendered.
Okay, well, that having been established, would you move on?
Sure.
Yes.
Having determined that the installation of backup fuel services was prudent, in your mind, does that mean that it is a good thing for customers that those backup fuel systems were installed?
Objection. He's doing the same thing. He's basically just using a different word to say what this commission's already decided.
I think he's asking for the witness's opinion of that, not a definitive statement, but his opinion. And I think that's permissible overruled.
A backup fuel source provides a greater degree of certainty that the units at Dave Gates would be available to operate.
So does that necessarily mean that even though interruptions may be uncommon, that protecting against potential interruptions by installing a backup fuel source is a good thing for Northwestern and your customers, right?
Depends on the situation. In Dave Gates, it was deemed prudent to do so.
Okay. If a facility does not have a backup fuel source and is interruptible, isn't it possible that that facility would be unable to operate during critical times like extreme weather events?
There is a possibility, and I think what you're getting at is a dual fuel source at Arrow the appropriate least cost proxy resource to calculate avoided costs.
Well, that is the subject of my inquiry, but so as to avoid asking you a legal question, I'm trying to lay a factual predicate for that legal conclusion.
Okay. All right.
So can you answer my question?
Okay. Please ask it again.
If you don't have a backup fuel source, then it is possible that during extreme events, that resource may be unavailable to serve customers, right?
Possible, yes, with a degree of probability. I don't know. It's possible.
Sure. But the possibility of interruption was sufficiently likely that Northwestern installed backup fuel sources on the existing units of DGGS, right?
I'm just going to object. We've gone over this multiple times, so these questions are essentially asked and answered and in the record already.
Northwestern criticizes Mr. Gorman's calculation of avoided capacity cost using Yellowstone as a proxy resource, correct?
Correct.
However, isn't it true that Northwestern has not provided the commission with an alternative analysis of what the appropriate avoided cost would be if the commission determines that a new unit like those at Yellowstone is a better proxy resource than the new unit at DGGS, right?
Are you asking if we provided an alternate avoided cost calculation for based on YCGS?
Yes.
Okay, I did not submit in my testimony an exhibit stating as much.
All right, let's talk about your proposed PPA. Can you please go to your testimony at page 29? And let me know when you're there.
I'm there.
On line 14 at page 29, you testify that Northwestern proposes to limit the maximum output of the facility, that being the Kelp facility, to its nameplate value of 42 megawatts. Is that correct?
Yes.
Would you agree with me that when you use the word nameplate value of 42 megawatts, what you mean by that is the plant's maximum output net of parasitic loads?
Yes.
And that 42 megawatt is included in your PPA under the definition of nameplate capacity. Is that correct?
Without referring specifically to that,
I apologize. Like if you look at your exhibit SIS1, and I'll call your attention particularly to page 7.
I'm there.
Do you see at the top of page 7 a definition of the term nameplate capacity?
Oh, I'm looking. Yes, I do.
Okay. And when you write that in the PPA, do I understand it correctly that as you use that term and as you have defined that term, that you mean net of parasitic loads?
Yes.
Okay.
Yes.
All right, while we're at SIS1, can I ask you to flip back a couple of pages to, sorry, not back. Hold on. Flip forward a couple of pages. I apologize. I have the wrong page reference. Hold on. Oh, there it is. I apologize. If you could flip to page 6.
Okay.
There you have a definition of the term mechanical availability. Do you see that, sir?
Yes, I do.
And you define that as the percentage of time that the facility is capable of producing energy during each month of a calendar year, and is calculated as follows: bracket available hours divided by period hours, end bracket, times 100. Is that correct?
Yes, that's correct.
In the context of KELP, how do you apply that definition of mechanical availability to a coal-fired power plant?
The definition is there essentially because it, as often happens with these PPAs, it plays into other portions of the PPA. And what Northwestern is saying by defining the term mechanical availability is that it later plays into another portion of the PPA that says because we're paying KELP for its capacity, we're essentially saying it has to be mechanically available, which is why we had to define what does mechanical availability mean.
Sure, and I appreciate that. And if you prefer, we can go to page 11 of the contract and section 5.4, which I believe is what your answer refers to. Is that correct?
Yes, yes.
Okay. So let's focus then, if you prefer, on 5.4. The contract that you propose says that the facility shall achieve a minimum mechanical availability of 75%, quote, mechanical availability guarantee, end quote, for every month of each contract year, correct?
Correct.
Okay. And then it says, within 45 days after the end of each contract year, sellers shall provide documentation in a form acceptable to Northwestern to demonstrate the mechanical availability of the facility for each month in the applicable contract year. You see that?
Yes, I do.
What does that look like?
Essentially what Northwestern, exactly what that looks like is could be discussed, but what Northwestern is looking for is, was the facility offline for an extended period of time such that they weren't available to generate energy? And we just need to see that, no, the facility was operational.
If the facility generates 1 kilowatt hour a day, would that satisfy the mechanical availability guarantee in section 5.4?
It's not necessarily dependent on the number of kilowatt hours generated. It's just simply, is the facility available to generate energy?
So the facility could generate no kilowatt hours every day, but document that it was available and comply with this requirement. Is that right?
Yeah, I believe, because it's simply just whether it's available to generate, not how much it's generating.
And your contract doesn't have any requirement that the mechanical availability guarantee come with any minimum level of energy generation, correct?
Generally, I think that's correct. I'm not aware of how that would tie.
No minimum amount of capacity other than being available. Doesn't have to actually provide capacity, right?
Right, because based on the RAP accreditation of the facility, RAP is looking at their we're suggesting RAP's methodology for capacity accreditation, which is based on availability.
Were you present in the room when counsel for Northwestern was cross-examining Mr. Gorman yesterday?
Yes, I was.
Recall a series of questions that counsel for Northwestern asked, essentially talking about under KELP's PPA, whether the capacity commitment that KELP made meant that on average, they could produce in peak hours between 22 and 42 megawatts. Do you recall that discussion?
I do recall that.
Recall the discussion then about whether or not the fact that KELP could go between 22 and 42 might create challenges from a scheduling perspective from Northwestern's perspective. You recall that?
From my standpoint, what I was thinking about during that time is because of the variability for the facility to go from 22 to 42, that the capacity that the facility can output can vary between that. And when we talk about capacity planning on the supply side, we want to know, is the facility going to be there during a peak time? Not on the average, is the facility going to be there during a peak time? So that's why it's problematic from an average standpoint versus a firm commitment of this is the capacity that's available.
So you understand that when you say the capacity that is available, that a coal-fired power plant does not have the ability to instantaneously ramp up its output, right?
Right. It has a ramping rate.
So which approach provides more certainty to Northwestern's operators? An approach where in peak hours, the average or the output can range between 22 and 42 megawatts with an average of 37, or an approach where the output can be 0 for the entire month, or 42 megawatts the entire month.
Can you ask the question again? It was an operational question, and I just want to make sure that.
So,
aware.
let me try to unpack it because I've been properly criticized for that in the past. So your contract says you have to be available, but what that means is when KELP actually schedules any given day, KELP can choose to schedule 0. They can choose to schedule 42 megawatts as long as they are available, right?
Right.
Under KELP's contract, they're proposing a capacity commitment, particularly during peak hours, for example, of 37 megawatts, which as Northwestern's council discussed with KELP, means you can go between, for example, 22 and 42, right?
Right.
Okay. As between those two scenarios, which one is easier for the Northwestern system to plan for? Going from 0 to 42 or 22 to 42?
I can't answer that from an operational perspective. I'm not sure if it would be problematic from that perspective. So a different witness could answer that from a capacity planning standpoint. When we propose the RAP methodology for the availability of the facility, that's actually the capacity that would be accredited to that facility. And that's what we're proposing. From an operational perspective, I can't answer the question. I'm just saying from a planning standpoint, Northwestern can count on the facility when it's using a RAP methodology.
let's talk about section 3.7, which is on page. Oh, I guess now I realize why my notes are screwed up. I apologize. There's a page at the top of there's a page number at the top of the page and one at the bottom of the page. I apologize if I've been confusing on that. So I'm going to talk about the page number at the top of the page.
Okay.
On page 10, section 3.7. Do you see that, sir?
I do see that.
You see the language in the second sentence where it says, seller represents and warrants that 1, no portion of the site and the improvements thereon have ever been used to the knowledge of the seller by previous or current owners or operators or seller to generate, manufacture, refine, transport, treat, store, handle, or dispose of toxic material, hazardous substances, solid waste, or hazardous wastes, as the terms are defined in any applicable environmental law, and sellers shall not use any of the site for such purpose. Do you see that sentence, sir?
I do see that.
Do you understand that coal ash, for example, is a toxic material as defined by environmental law?
I do.
So wouldn't it be correct that if your PPA were approved, KELP would be in violation of that provision of the PPA and in breach of the contract on day one?
Northwestern is open to modifying the language of 3.7 such that KELP would not be in violation of the PPA. It would anything in this particular section that needs to be rewritten, as long as KELP can generate or can answer sufficiently why it would be in breach of the language as proposed. Northwestern is open to modifying the language as needed in that section.
Can you please look at page 23 of your testimony?
I'm there.
All right. Call your attention to line 15 of that testimony.
Yes.
You state also Northwestern's proposed PPA is based on the RAP accreditation. If the commission approves the historic ELCC method instead, it would require Northwestern to rewrite certain contract terms because Northwestern's proposed PPA is based on its participation in the RAP. You see that, sir?
Yes, I do.
Would I be correct that essentially the contract terms that would not work is the way that the contract proposes to calculate and compensate for capacity?
The schedule of Northwestern's capacity need in my exhibit under the proposed PPA would be different under the ELCC method as opposed to the RAP. There may be other changes that would be required in the contract as well that would have to be fully contemplated if the RAP methodology is not taken into account.
And essentially that's because your capacity pricing structure directly relies on the RAP and the RAP methodology to operate, right?
Northwestern's proposed capacity need is based on the RAP. And so that's why the schedule of the years through the term of the KELP project shows Northwestern's doesn't need KELP capacity until 2032.
Sure, and I appreciate that. And when you say it relies on the RAP, it's not just that it relies on the RAP at the beginning of the contract. Your contract relies on the RAP and the RAP calculation throughout the life of the contract, correct?
That's correct.
As a result of that, if the RAP is not approved by FERC, your PPA as written will not work, right?
Not necessarily. A version of the RAP calculation could still be in existence. So I don't know what the consequence of a denial by FERC would be in terms of if it wouldn't work. We're proposing the RAP in this PPA because we're doing our capacity planning based on the RAP.
And I understand that. What I'm saying is if the RAP doesn't exist, then it will be impossible to perform the calculation required in the PPA as to whether or not the RAP has determined a capacity need, correct?
Objections asked and answered. He's calling for a legal conclusion.
If I may respond, this witness's own testimony says that if the RAP methodology is not used, the contract needs to be changed. I think I'm entitled to explore with the witness what changes he contemplates and what that means in terms of this commission's consideration of the PPA he proposes.
You just asked that question and he answered it
Answered it how?
with his response to the prior question.
What did he say?
I'd have to read back through the record.
What's your understanding of what he said?
I'm not the witness in this case, with all due respect.
I
Mr. O'Donnell.
find that the witness is very reluctant to give clear answers to things, open to interpretation on there. It seems to me that the question was, in the absence of RAP, can you still maintain the requirements that are imposed upon the contract by RAP? It seems to me a very simple question. In the absence of any overriding rules that you have to comply with, do you have to comply with them? Is that, Mr. Nelson, is that fair to characterize your question in that way?
That is what I was attempting to understand from the witness, how a denial of the RAP would require a change to the PPA that he is proposing, as suggested by his testimony. He doesn't trigger the event because the RAP is denied. He triggers it because this commission approves a different methodology, but the outcome is the same. And so I was trying to understand what the implications of that were.
Yeah, and I thought he had already answered that and said that there was other methods they could use this similar type of methodologies, and he explained himself. And that's what I'm saying. I think the question has already been asked and answered.
Overruled. Thank you.
The RAP accreditation, what Northwestern was offering in the PPA was a schedule of Northwestern's capacity need as determined by RAP. That particular schedule of need, in the unlikely event that RAP never exists and there's no calculation, there would potentially have to be some kind of an amendment to or a methodology defined to establish what the capacity accreditation is of the KELP facility.
But is it fair to say that at a minimum, would you agree with me that the language of the PPA you propose would have to be changed, right?
If the RAP is not accepted by the commission, if the RAP methodology is not accepted by the commission, there would have to be changes.
Appreciate that. Would you agree with me that there would also have to be changes if the RAP is not approved by FERC?
I guess it seems like an easy question to answer, but the reason why I struggle is because I don't know what would result if the RAP was not approved by FERC, or what other methodology would be in place. So that's why I struggle answering that question. There potentially would be a program like the RAP in place that is used. So that's why I'm struggling with that.
So, and I apologize. I'm not intending to explain that it's not possible to fix that. What I'm asking is, the language as written would have to be fixed to address whatever happens instead, right?
Asked and answered. Objection asked and answered.
I agree it was asked. I do not agree it was answered.
Yeah, the answer was very vague, overruled on there. If you would be more direct with your answers, please.
Okay,
I understand it's complicated, but it's not you're not being very helpful.
I believe an amendment would be required.
Very good. Excellent.
Okay.
Thank you.
Thank you. All right. If the RAP is materially altered or amended by the FERC, as contrasted with what is presented in the filing, is it possible that the PPA, as you propose, would also have to be amended?
You use the word materially. I would say it's possible.
If the RAP is altered or amended, skip the word materially, during any point in the time of the life of the PPA, so over the next 20 years, is it possible that the PPA would have to be amended at that point in time?
I believe RAP has stated that their capacity accreditation methodology could potentially be subject to change. So if a material change involves exactly how KELP's facility receives its QCC value, that could remain. What would be fixed based on our offer in the PPA is our capacity need in our portfolio. So that part would not have to be amended according to RAP, because we're proposing that we fix a snapshot in time of our portfolio according to KELP's claimed LEO date.
Let's try it this way. If Northwestern decides ultimately not to join in the binding phase of the RAP, at that point in time and thereafter, the PPA you propose in this case would need to be amended, correct?
So Northwestern fully expects to announce a joining of the binding phase before the end of the year. I'm not sure. Please ask the question again. If I just need to understand what the question is so I can answer it as best as possible.
If Northwestern decides not to join in the binding phase of the RAP, your PPA would not work at that point in time, correct?
Not necessarily correct. Northwestern could potentially join the RAP at some other time, and the PPA would still work.
Okay, fair enough. So would you agree with me that in any years when Northwestern was not part of the RAP, the PPA won't work as written and would need to be amended, correct?
The RAP could still theoretically give the capacity accreditation to the KELP facility if Northwestern was not in the RAP.
But if Northwestern wasn't in the RAP, would the RAP still give a capacity accreditation to the rest of the Northwestern fleet to determine whether or not there is a capacity deficit?
So the answer to that is the capacity need for Northwestern if Northwestern is not in the RAP at some future date, the capacity need of Northwestern would be different than what the RAP proposes, because Northwestern wouldn't be calculating its resource need according to RAP.
That's right. And the PPA contemplates a calculation of resource need using the RAP, not ELCC, for example, correct?
Yeah, and the resource need would remain static according to what we offer in the proposed PPA.
Does this commission decide whether or not Northwestern participates in the RAP?
No. To some extent, well, let me just say I don't fully understand, and it would be a qualified answer to that. So it's Northwestern Energy's decision.
For example, if Northwestern announces later this year that you're going to join the binding phase, there is no process at the commission for Northwestern asking permission to do that, right?
That's my
Yeah, I'll just object. He's asking for a legal conclusion.
The question was that there is no process at the commission. That's asking for a fact, not whether there must be.
I think the witness answered that he doesn't know.
Fair enough. Do you believe as a general principle that negotiations typically involve some degree of give and take by all of the parties?
yes.
Would you agree with me that the first time that Northwestern presented a PPA to KELP throughout the course of our dealings for an extension was when you filed your testimony in this proceeding?
Yes.
In response to that, KELP filed rebuttal testimony, correct?
Yes.
You agree with me that in rebuttal testimony, Mr. Gorman identified several portions of Northwestern's PPA that KELP could accept, correct?
Yes, he did.
You reviewed KELP's proposed PPA prior to filing your testimony, correct?
Yes, I did.
Yet your proposed agreement rejected KELP's proposal in its entirety, didn't it?
I would say that it's a qualified yes, in the sense that Northwestern is attempting to propose a PPA that's similar to all of the other QFs. And in that regard, we want to be fair to all the QFs, which is why we propose our standard PPA language modified to the best of our ability for the KELP facility, recognizing, as you pointed out earlier, that there are maybe certain provisions that KELP simply cannot abide by in the environmental section that Northwestern would be open to modifying based on a reasonable explanation by KELP.
So how does Northwestern imagine a negotiation and give and take to occur at this point in time, since we are now in front of a proceeding before the commission?
Certain terms will be decided on by the commission, but not necessarily all terms. And they may kick it back to Northwestern and KELP to decide on the terms that are not necessarily set by the commission order. And so that's where certain give and take could take place.
Mr. Nelson, being that exactly 12 hours ago, we took a break for the evening. We're now at the midpoint of the day. How long do you expect to be with this witness? Is it convenient to stop now and take a break, or to continue on if it's a short period of time?
I expect another 2 seconds.
Ah, very good. Wonderful news. Proceed.
That's all the questions I have. Thank you.
Oh, how timely. So you were timely last night in ending your right at 5 o'clock, and you've done it again, Magoo. Thank you. So we will at this time take a lunch break until 1:15. We're off the record.